Good morning, everybody. Thank you so much for spending April Fool's morning with us. We have a wonderful presentation ready for you, and we are just so glad to see so many people in the room. Many old friends, some new friends from Dauphin and Kelowna and all over BC. So thank you very much for being with us this morning. So just our usual introduction. I think many of you have seen this before, but just to remind you that our advanced team start with Dr. John Higginbottom. It was his idea to develop these webinars, and so we're very grateful to dear John for his ideas in helping advance our work. To Jordan Clark, a big thank you to him for administration, technology support, and just his ongoing work. To Matthew, who's our constant companion and technological support in the moment. Very grateful to Matt for all his help. And myself, Regina, a warm welcome to you. You'll remember that BC Advanced Practice is funded by the Ministry of Health in BC to provide leadership, education and guidance to the mental health field and to help develop and put effective evidence-based psychosocial rehabilitation practices into place. We're very grateful to our instructors for their support and expertise. And we have about 23 archived sessions available to you. We're hopeful that they are of benefit to you and may provide an opportunity for further education for you and for your team. So should you have any ideas about topics you would like to present, we would very much like to hear from you. We're beginning to go into planning for our summer series, so we'd love to hear from you about ideas. And if you are willing to do a presentation, we're very happy to hear from you. So PSR BC Advanced Practice, really our purpose is to help transfer evidence-based knowledge, provide expert clinician consultation to people who may be interested in that, provide training and education, develop our website resources, and supporting the Provincial Advisory Committee and Committee for PSR Practice. So this unique webinar series is the second employment series that we've been offered. We're very grateful to the Ministry of Advanced Education for some funding to provide this education to you. So a big shout out to them. So our series, this is the fourth you'll know in this particular series, and please, we look forward to having you for the next session on April 29th for positive behavioral supports and employment. Please do note that session will begin 1 hour later, and then the final panel to come to chat with some of the experts and bring your important questions, and that will complete our series on employment. Just want to bring to your attention a new program that we learned about yesterday around suicide prevention training for British Columbia, supported by Canadian Mental Health Association. Just leave you with a contact person, Steve, if you're interested in finding out more information or perhaps interested in gaining some specific training for your organization. So please feel free to contact Steve at that address, but it just seemed to be a very important and timely support for practice. So we just felt that we'd like to bring that to your attention. And now we come to our presentation of today. We have two wonderful speakers with us today who are going to bring, I think, a unique perspective, just thinking about that intersection between law, mental health, and employment. So we begin with Suzanne Kennedy. And Suzanne is a genuine person who understands the importance of teamwork and collegiality. She incorporates these values as she assists clients to resolve complex and time-sensitive issues. She has a varied practice with a strong focus on education, law, health law, privacy matters representing both public and private sector clients. During her career of nearly 2 decades, Suzanne has represented various healthcare and educational professions and organizations and has provided advice to clients in a range of areas including employment, professional regularity proceedings, court and administrative tribunal proceedings, procurement, contract negotiation, and strategic advice and opinions on regulatory compliance. Suzanne has also written and presented on a range of topics to assist professionals in matters affecting their responsibilities and practices. We'll also hear from Lou Poskitt, who advises and represents represents private sector employees, primarily in hospitality and retail sectors, with a particular focus on human rights and labour laws. She has extensive experience providing training and accommodation issues, responding to human rights complaints, filing applications to dismiss, resolving grievances, and advising on collective bargaining. Lou has appeared before the Human Rights Tribunal, the BC Labour Relations Board, various boards of arbitration, the Provincial Court of British Columbia, Supreme Court of British Columbia, and the BC Court of Appeal. So we recognize that we have people in the room who provide very specific expertise. I'm grateful to both Suzanne and Lou for their time this morning. So with no more, from Regina, I'm just going to pass you first to Suzanne. Thank you.
Good morning. It's kind of strange to be giving one of these sessions without having faces looking back at me, and I'm trying very hard this morning. I'm told this is the first time you've had lawyers give a session to your group, and I'm trying very hard not to read something into the fact that you've scheduled us for April Fool's Day. We've been asked to come up with some topics that represent from a legal perspective issues where there may be an intersection between the workplace and mental health issues. Lou and I thought it might be helpful to begin this discussion by covering sort of two meaty topics. We'd like to give a general discussion about some privacy issues that arise in the workplace, and then we'll talk about human rights issues in the workplace and issues around discrimination. So just to sort of give you a quick roadmap of where we'd like to take you today, I'm going to begin today by discussing just a general overview of privacy rights in employment in British Columbia. So just a kind of an overview of what employers can collect, what information they can collect, use, and disclose about their employees. And then just a discussion about what rights an individual has to access information that their employers may have collected about them. Lou will then take over and lead a discussion about discrimination and human rights issues. And so she'll give you an overview of the human rights process, an introduction to the duty to accommodate, when does it arise and what does it acquire, what must be accommodated and what need not be accommodated. What do we mean when we're talking about the concept of undue hardship? She'll also be dealing with issues around some of those invisible disabilities, and here mental disabilities, addictions, and some types of misconduct that trigger those issues. I'll lead off with a discussion about privacy rights. I understand we have a mechanism here to take questions. I'll pause at the end of my presentation to address any privacy-related questions, and then I'll hand the floor over to Lou. But certainly don't feel like you need to wait to the end of the presentation. I'm happy to take questions as I take you through my slides here. Let me just begin by explaining that in British Columbia there are three main privacy statutes that apply. The Personal Information Protection Act, represented here by the acronym PIPA, is a piece of privacy legislation that governs the collection, use, disclosure, and security of information in the private sector. There's a parallel piece of legislation that applies within the public sector, so government bodies, universities, schools, health authorities, hospitals, ministries. Government entities are governed by this second piece of legislation, and many of you may have heard about it. It's called the Freedom of Information and Protection of Privacy Act, and it governs the collection, use, disclosure, and security of personal information that's collected within government. So we have those two parallel pieces of legislation, and which one applies to the employment relationship will depend on whether you're working within the private sector or the public sector. There's a third piece of legislation that sometimes comes up, and it's a federal piece of legislation called PIPEDA, or the Personal Information and Protection of Electronic Documents Act. And it applies in industries that are federally regulated, so airlines, telecommunications, banking. It comes up less frequently, but in those areas that are federally regulated in the private sector, that's the piece of legislation you would be dealing with. For our purposes today, I'm not going to deal with all three pieces of legislation. I fear that if I did, I would bore everyone to tears. But I will tell you, I'm going to focus mostly on the Personal Information Protection Act, which is our private sector legislation. But I will tell you that all privacy legislation in Canada has certain key commonalities, and so much of the themes that I'm going to touch on represent provisions in the legislation governing the personal information across the country. So these concepts are generally applicable. Just turning to this slide, about the Personal Information Protection Act, again, applies to private sector organizations, and it governs and imposes limits on how organizations can collect, use, and disclose personal information. Generally, the principle is that when an organization, an employer, is collecting information about an individual, it should have the consent of the individual to the collection of that information, unless the legislation allows it to collect without consent, or in certain circumstances, consent can be implied. The legislation also has provisions that require organizations to take reasonable steps to ensure that they protect all the personal information that they collect. So they have an obligation to act reasonably to ensure that they have security mechanisms in place and they're not being reckless or careless with how information is stored or who has access to it and so forth. This legislation also provides individuals with a right to access their own personal information that is collected by organizations. So if you're a customer of Canadian Tire and you want to know what Canadian Tire collects about you as a customer, this legislation gives you the entitlement to ask the question and receive from Canadian Tire copies of any personal information about you that they collect. The legislation also, and this becomes more important in the employment sphere, it also creates limits on how much information can be collected and the purposes for which information can collect, an organization can collect information. So there's sort of a general principle here that organizations should be collecting our personal information only to the extent they need it for their legitimate activities and not for other unrelated purposes. So that helps to give you sort of a general overview of sort of the key themes or the key obligations that arise from the Personal Information Protection Act. All of these same concepts and themes, again, if you're an employee in the public sector, all of these same concepts are embedded in the Freedom of Information and Protection of Privacy Act. One difference about the Freedom of Information and Protection of Privacy Act, and on this next slide you'll see the acronym FIPA, that's a reference to the Freedom of Information and Protection of Privacy Act, is it actually includes in its provisions a broader right that any member of the public can access records that are in the custody and control of government. So if you work in the public sector, you're probably familiar with this, but under this legislation, any one of us can file a request with a government body that's covered by this legislation and request any record that is within the custody and control of that government body. So the public has a general right of access that's not just limited to a person's own information. In the private sector, your right of access to information is limited to your own information. But in the public sector, all citizens have, as a matter of sort of general transparency and accountability, this ability to ask for anything that is within the custody and control of government. Now, that right of access is subject to some limitations, and there are exceptions. And of course, the record has to be one that's within the custody and control of the public body. So, and how that custody and control concept is defined has been sort of broadly interpreted. So, it might include records that are in the possession of third-party service providers to government, but it doesn't include increasingly the personal records of employees. So, one issue that's recently come up in some of the case law is an issue about whether when employees are using their personal email or their work email for personal purposes, whether those records fall within the custody and control of their public sector employer. And we've got some case law telling us that that perhaps there is a good argument to be made that even though you've used your work email for a personal purpose, you might be able to keep that information outside the scope of the right of access under that legislation. So that's an interesting issue that's developing and would be one worth watching if you're working in the public sector and might, as all of us I think occasionally do, use your email for purposes that aren't strictly related to work. Under privacy, all privacy legislation includes this concept of personal information. What do we mean when we're talking about personal information? Because when increasingly in privacy law, when we're talking about privacy, in most cases what we're really talking about is how organizations collect and use our personal information. And that's defined very broadly in the legislation as simply information that is about an identifiable individual. So obviously that includes the information like your name, your social insurance number, your home contact information. That's all obviously your personal information. But when you start examining other types of records, a question can sometimes arise about what do we mean by personal information. And it's really interpreted quite broadly. So for example, another person's opinion about you, that's your personal information. So we really look at what constitutes personal information in a very searching way, and it's a principle that's interpreted quite broadly. Now, if we turn back to sort of the PIPA legislation, the Personal Information Protection Act allows employers to collect, use, and disclose personal information without the employee's express consent for the purposes of establishing, managing, and terminating the employment relationship. There isn't a requirement for consent, as I've said, but the employer is under an obligation to act reasonably in terms of what they collect and how they collect it. So this principle of reasonableness and what's reasonableness for organizations to collect and how they use it and the methods they use to collect it impacts a number of different practices. So this concept of reasonableness, for example, impacts the extent to which employers can do things like conduct searches of email accounts and implement surveillance in the workplace. What the legislation tells us, again, is this idea that an employer can collect employee personal information. And again, that's the information that's reasonably required to establish, manage, or terminate an employment relationship. But if an employer is collecting information that doesn't fall within that reasonably required language for these employment purposes, then that's information that they should be collecting with notice to the individual and consent. The other point here is that even though the legislation does permit an employer to collect employee personal information for the purpose without consent, there is an expectation that employers will provide notice to employees about what they are collecting and why. Now, there's some exceptions in the legislation where notice isn't required, but generally speaking, most employers under this legislation should have a policy or some form of notifying employees about what it is they collect and what employee information they collect and what they do with it. I guess that just one other thought I'll leave you with on this point is that this idea of what's necessary to manage, establish, manage, or terminate the employment relationship isn't really well defined by this legislation. But just to give you sort of a flavor, it's going to include information like human resources records, supervisory activities, personnel. Most of the records contained in the personnel file fall within this language. Job applications, performance evaluations, disciplinary records, investigation records. All of that falls within the scope of this language of information your employer is entitled to collect without express consent. But again, if it doesn't fall within the meaning of that definition of employee personal information, then it's information that the employer should be collecting with notice and consent, unless there's an exception in the legislation that allows collection without consent. So what's not employee personal information This legislation doesn't apply to business contact information, so it's legitimate for your employer to be disclosing information about how you can be contacted at work. This doesn't apply to work product information, so your employee personal information doesn't include information or documents or work product that you've prepared in the course of your employment. And it doesn't include information that isn't necessary for establishing, managing, or terminating your employment relationship. So, emails about that may be on the workplace email system about weekend activities or birthday celebrations, those wouldn't generally fall within this definition of employee personal information. This legislation also imposes some obligations on employers about what information they're required to retain. So if an employer collects information about you and then uses it to make a decision that directly affects you, then the legislation says that there's a requirement that the employer keep that information or those records for at least a year. Now, really, the reason for that is to allow the employee to have a reasonable period of time to access that information if they want to see it. There are also obligations under this legislation which requires employers and private sector organizations to ensure that they do securely destroy information. And information should be destroyed when it's no longer necessary. So again, this sort of comes back to this concept of acting reasonably, and the principle is under privacy laws that organizations should only collect what they need. They should only use it and disclose it to the extent that they need to do so, and they shouldn't be retaining it unnecessarily unless there's a reason or justification for doing that. And then this brings us to this concept of the security of personal information. And one of the aspects of privacy legislation in British Columbia is this concept that organizations that collect and use our personal information should be accountable and responsible to maintain the security of that information. So the legislation imposes a positive obligation on public bodies and private sector organizations to ensure that information is kept secure. And what constitutes appropriate or reasonable security measures is going to really depend on the nature of the information. So the more sensitive the information is, then the higher the obligation will be. So your medical information, mental health records, disclosures that have been made about health or mental health issues are the types of records that we would generally consider to be highly sensitive, and for that reason would attract a higher and better obligation to maintain its security and to limit access to other employees in the organization that have a need to know or have a reason they may need to see that information. The same principle would apply to financial information. Financial information, social insurance numbers, banking information, all of this type of information is information that if it falls into the wrong hands can be used for the purposes of perpetrating fraud or identity theft. And for that reason, there would be sort of a higher expectation that organizations would ensure that there's stronger security arrangements that are in place. So what do we mean by security arrangements? Physical, I mean, here it's really sort of spans the spectrum. An employer would want, and an organization would want to ensure that they have physical measures in place, that there are electronic measures in place, but this also encompasses limiting access within an organization to sensitive information on a need-to-know basis. So this concept of reasonable security measures would not, for example, permit employers to indiscriminately discuss information about employees who might be off on sick leave, or sort of disclose medical or other personal challenges that employees may be facing for reasons other than sort of that are legitimate to managing the employment relationship. So even within an organization, these principles apply to ensure that sensitive information is being accessed on a need-to-know basis and isn't subject to unlimited access to people who might just have idle curiosity as opposed to having some legitimate workplace reason for accessing it. Okay, let's turn to this issue about what are your rights regarding personal information. As I've already said, anyone is entitled to request access to their own personal information. In fact, under most privacy statutes in Canada, an individual is presumptively entitled to access their own personal information. Your personal information, again, includes all of those things that we would expect: your name, your contact information, your social insurance number. But it may also apply to other types of records, like other people's opinions of you. Now, there are some exceptions to your right of access. Materials that are subject to solicitor-client privilege, for example, an organization isn't required to disclose those. Where an employer is conducting an investigation and the investigation or any legal proceedings flowing from the investigation isn't completed, an employer doesn't have a positive obligation to disclose those records if they include some of your personal information. And an organization can also withhold its own confidential commercial information if its disclosure would otherwise harm the interests of the company. But the legislation also sets out some exceptions to disclosure that are there to protect the interests of other individuals. So your employer won't release to you, for example, records that contain your personal information if by disclosing those records they would be revealing personal information about somebody else. They would be expected not to release information in circumstances where that might represent a threat to the health or safety of another person. So think of a situation there where there may be a fear of domestic violence, or a fear that if information, harmful information or upsetting information were released to an individual, there was a concern that individual might cause some harm to themselves. Those might be the types of circumstances that would give rise to a concern about whether disclosure might give rise to a safety risk. The legislation also doesn't allow an organization to release information that would disclose that somebody's provided a personal evaluation or opinion about another person if disclosing that information would reveal that person's identity. So this starts to give you a picture of is that, well, you're entitled to your own information, that there are limits, and those limits are generally there to protect other important interests, like the ability of the employer to investigate, to ensure that third parties are not subject to harm, or that their interests aren't sort of unduly damaged by disclosure. So there's a bit of a balancing that goes on before a decision is made to release this information. This next slide is just here to illustrate that under the Freedom of Information and Protection of Privacy Act, a similar set of exceptions to disclosure apply. Individuals also we all have an ability to challenge an organization in terms of the accuracy of the information that they keep about each of us. So this legislation imposes on organizations a positive duty to be accurate and complete in the personal information that they retain. But if an individual has a concern that there may be an inaccuracy or information that's been collected about them by an organization is incorrect, they can, under this legislation, make a request and require the organization to conduct a review. And if the correction the individual points out is sustained, then the organization has to make a correction to that information, and that may require them to notify any third parties with whom they've shared that information. So you have an ability to say, hey, I think that your conclusion here, or what you've noted in this report, is not correct about me, and I noticed that you've provided this report to 3 other people, and I'd like you to look into it, and they can then be required to provide notice of that correction to other third parties. So that's a helpful tool to understand is available. In fact, even if an organization doesn't agree with the correction, the legislation still would require them to annotate the records to ensure that the record includes a notation that you've requested this type of a clarification or correction. So it allows an ability, at least for the record, to reflect that there's been an objection noted or concern expressed about the accuracy of the information that's been collected and retained. Another issue where privacy seems to be coming up in employment much more frequently is around pre-employment screening and conducting background checks. And increasingly, our privacy commissioner has begun sort of expressing concerns about sources of information that may be accessed by employers in the course of screening employees for employment. And this really sort of comes back to this idea that the principle behind the legislation is that when your personal information is collected, it should be reasonable and it should be with notice to you. So you should be aware that your information is being collected. So as one example, there's been some recent case law about consulting with references. And there was one recent case where an employee applied for a position within a government ministry and provided 2 references. The employer was not satisfied with the references that were provided in the job application because the human resources director felt that there wasn't sufficient supervisory representation on the list of references. But what the human resources director noted was that the employee had previously worked in another area of the ministry, and so the human resources director picked up the phone and called an individual within that ministry without giving any notice to or seeking the consent of the employee and the prospective employee. And so in that case, the job applicant did make a privacy complaint about that collection of information, and the privacy commissioner agreed that in the circumstances that the steps that were taken weren't reasonable or necessary, that if the employer was not satisfied with the job references that had been provided, that really the least privacy invasive step to take was to contact the job applicant and ask for some additional references. And if no additional references were supplied, then at least to give notice to the individual that that the human resources director intended to contact other people within the ministry and, if possible, get consent to that. So that case sort of provides a useful illustration of when we're talking about only collecting what's reasonable. The other factor that comes into play when we're talking about what does this concept of reasonable means, and reasonable sort of implies that the steps you take to collect information, how you collect it, and what you collect should really take the least invasive path available to you in order to get reliable information. So those same principles apply when employers have attempted to require employees to go through credit checks as part of the employment application process. And there have been a couple of cases where the privacy commissioner has made the point that if you're going to require an employee to go through a credit check, you really need to be able to demonstrate that there's a real nexus or connection between the information that you will get back from the credit check and the job the person is applying for. So there's a recent case out of Alberta where an individual is being hired to handle cash, and the employer wanted to have the job applicant undergo a criminal record or a credit check, and a complaint there was made to the privacy commissioner. And again, the privacy commissioner there agreed that that was unreasonable because just because somebody may have mishandled their own finances didn't necessarily imply that they were not trustworthy or capable of managing cash. And so taking that step or requiring that additional information fell outside the scope of what was considered reasonable. The same type of analysis applies to criminal record checks. That if criminal record checks are going to be required as part of the employment application process, that the employer should be in a position to demonstrate that there is some need or connection between the information that the criminal record check would reveal and the specific position that you are hiring for. So that's these principles, and I'll tell you that these principles are also coming up around the use of social media. Now, it may seem like the most natural thing in the world for a human resources department to receive an application and call up the internet and Google the person's name and see what comes up. But our privacy commissioner in British Columbia has also weighed in on this issue. And while our privacy commissioner acknowledges that it may seem inconsistent that this is information that is public, information that's available on social media sites, that the collection of information from those sources can put employers and organizations offside of privacy principles because, again, often the information that you find on social networking sites and social media sites isn't really very connected to the employment relationship. So, looking at someone's photos from their weekend activities on their Facebook page or their photos with their kids or what they do with their friends on the weekend isn't some information that's really related to often or necessary to the employment relationship. So again, we come back to that issue of examining the relationship between the information that's being collected and how it's connected to the employment relationship. So an employer might have an easier time justifying looking at a LinkedIn professional profile on the internet than going as a first step to a Facebook page or something that is more strictly social. Yeah. Okay, so let's go to Ingrid's question first. What's the recourse for an employee if their privacy rights have been violated? Virtually every jurisdiction in Canada has a piece of privacy legislation, and there is a privacy commissioner appointed under the legislation. And so our privacy commissioner in British Columbia is Elizabeth Denham. And there is a process under the legislation to file complaints. So you would contact the Office of the Information and Privacy Commissioner with your concern, and they would probably ask you to provide some written particulars of the complaint, and then they would conduct an investigation into the complaint. And ultimately, if it can't be sort of resolved informally, a decision would be issued, and orders for compliance, if a privacy breach is sustained, could be issued. Rona's question is, can you give me examples of the areas of work where the employer does not have the right to request a criminal record check? It's hard to do that in the abstract, but I think to be able to justify asking for a criminal record check, you would have to have a situation where that information would be relevant. It's easier for me to give you examples of situations where a criminal record check could be required. So, I mean, we know by legislation in BC that anytime you're dealing with vulnerable adults or children and you're covered by the Criminal Record Review Act, that's legitimate and, in fact, legally required in some sectors to undergo a criminal record check. But I would think that it would be hard to justify a criminal record check in circumstances where there aren't issues of trust, or that the relationship isn't one based on trust, or you aren't putting in an individual in a position where they have the power or authority over another vulnerable person. So I think you'd have to look at the nature of the position and the nature of the duties, but there really would be an onus on the employer and the circumstances to justify why they need that information and whether it really gives them any information that is useful in making their hiring decision. I hope that was a bit of a dodgy answer. I know it's just that's not an easy one to answer in the abstract. Anything else? We can pause here for a moment if there are other questions. If not, that sort of brings me to the end of my slides, and I'm ready to turn things over to Lou. Okay, Lou, over to you.
Just bear with us for a second. We're going to do a quick seat shuffle.
So thank you for your questions. We're happy to take some more at the end as well. So we'll just give Lou a little bit of time to seat shuffle. Thank you kindly. Suzanne's just going to leave the room, but is happy to come back for the end of our presentation, which is great. And just with that, we'll walk you over to Lou. So welcome, Lou.
Thanks. And please bear with me. I'm dying of the plague. I don't normally sound like this. Normally, I'm dainty. Um, so I'm going to run you through we're going to kind of do a 30,000-foot overview of discrimination in the Human Rights Code and where those rights come from. And then we're going to drill down a little bit more into how that relates to mental health issues. So the rights that we're talking about today flow from human rights statutes. Thank you. Flow from human rights statutes. There are human rights statutes in all jurisdictions in Canada. There's a federal human rights statute which applies to people who are in employment relationships that are federally regulated, and then each province and territory has its own piece of legislation. For the most part, the legislation is all very similar. There's some little differences, but it tends to all be applied in a consistent manner, even where there are differences. And this legislation applies to all public and private, thank you very much, private sector employers. The legislation has been characterized as quasi-constitutional, so it doesn't quite rise to the same level as our Constitution, but courts and tribunals have consistently held that human rights legislation takes precedence over other statutes, and that it's to be read and applied in a broad fashion. And we'll kind of see what that means as we delve into this a little bit more. I'm going to be talking primarily about the BC Human Rights Code, which is the one that governs most employment relationships here in BC. There may be a handful of people who are governed federally. The provisions of the federal code are very similar to the code in BC. So the first place you start is really the purpose of the code. And the purpose of the code is to foster a society in British Columbia where there are no impediments to full and free participation in the economic, social, political, and cultural life of British Columbia, to promote a climate of understanding and mutual respect where all are equal in dignity and rights, to prevent discrimination prohibited by this code, to identify and eliminate persistent patterns of inequality associated with discrimination prohibited by this code, and to provide means of redress for those persons who are discriminated against contrary to the code. So you can see those are some pretty lofty goals, and I think there may be a bit of a breakdown between here's what the purpose of the code is and here's how people on the ground access those rights, and so we'll talk a little bit about that. So what we're specifically talking about today is Section 13 of the code, which is the provision of the code that relates to employment. But the code is actually more broad than employment. It covers protection to employment, accommodation, meaning not how am I accommodated in employment, but where do I live. So it covers things like tenancy and services ordinarily available to the public, amongst a couple of other things. There's publication and a number of other ones. But the one we're focusing on today is how does this relate to your employment, and what's the nexus between sort of mental health issues and employment, your rights under the Human Rights Code. So Section 13 says a person must not refuse to employ or to continue to employ a person or discriminate against a person regarding employment or any term or condition of employment because of a prohibited ground. So right away there's broad protections, but then that's narrowed to it's limited to just the protected grounds. So the protected grounds are, and this is a pretty crazy slide, I can't think of a better way of presenting it. We are talking about physical and mental disability today, mental disability today, but the prohibited grounds are race, sex, religion, ancestry, age, place of origin, marital status, sexual orientation, political belief, physical or mental disability, family status, color, and criminal conviction. And criminal conviction has an asterisk beside it. It's criminal conviction that is unrelated to your employment. So if you have a criminal conviction, sort of to pick up on what Suzanne was saying, that is related to your employment, that doesn't fall within the protection of the code. So that's just an important thing to flag. But you can kind of see there's a broad number of things that are enumerated. And it's sort of curious because some things are very broad. So sex and sexual orientation, they haven't really drilled down into. But when you're talking about race, you've got race and then color. So those seem highly specific. But what the tribunal has concluded is that all of those are very broad categories that are to be broadly interpreted. And with things like physical or mental disability, the other thing that is protected is the perception of a physical or mental disability. So even if I don't have or suffer from a mental disability, but I'm treated in such a way because my employer perceived that I had a physical or mental disability, that would also fall under the protection of the code. And really what this all comes down to is that your employer has a duty to accommodate. So if you have, if you fall under a protected ground and there is a nexus, and we'll talk a little bit more about that, but if there's a connection between that protected ground and something your employer is requiring you to do that you cannot do, your employer has a duty to accommodate that limitation or restriction. And we'll get into that a bit more. So the anatomy of a discrimination claim, just bear with me for a second.
Just a quick check-in to let you know that we've lost internet connectivity with our other mic, so we're going to take a quick pause to make sure we get that back, and then we'll be paused. So if you need to grab a coffee or take a quick bio break, we'll see you in a second. Thanks for your patience.
Okay, so we're apparently back. I am basically the Kim Kardashian of human rights. I broke the internet. So the anatomy of a discrimination claim, and this is really, this is sort of important. So the first thing you need to establish is there a prima facie case of discrimination? And what that means is you have to establish a link between, and we're talking about disability, but a link between the disability and the employer's conduct. So like I said, if there's a workplace rule and I can't meet those criteria because I have a mental disability and I can't, I don't know, let's say be in the office 40 hours a day, my mental disability requires that I can only be there 35 hours a day, and that's enough of a link between the mental disability or the protected ground and the rule or the conduct. And then the next question you have to ask is that discrimination the result of a bona fide occupational requirement? And what a bona fide occupational requirement is it's basically we have to accommodate you unless we can establish there's a bona fide occupational requirement. And what that looks like, let's see if I can, oh, things are happening. I cannot advance my slide. First click, and arrows. No? Sorry, guys. Suzanne did it so flawlessly. Okay, I think I've got my bearings now. So the bona fide occupational requirement test flows from a Supreme Court of Canada decision called Murr, and it was really a departure from the ways in which the courts had historically understood the protections of the code. And under Murr, the court articulated a three-part test. So if an employer has adopted a standard that they say they can't deviate from or you can't be accommodated, what the employer has to show is, one, that there's a rational connection between that standard and the performance of the job, that the standard was adopted in good faith and there's a good reason for the standard. And the third one, and this is where we get down in the trenches, the third one is that the standard is reasonably necessary and impossible to accommodate without undue hardship. And so quite often the employer can get through 1 and 2 quite easily with sort of establishing, here's what we need, here's what we're trying to accomplish, and here's the rule we've put in place. But part 3 is where the employers are required to show some creativity. And it's the standard of undue hardship has taken some time to understand. When these decisions first came about, there was a decision called Grizz Murr, where the Supreme Court said, the undue hardship standard incorporates every possible accommodation to the point of undue hardship, whether that hardship takes the form of impossibility, serious risk, or excessive cost. And so that was a pretty high standard. We'll talk about this a bit later. The court has dialed it back from the impossibility standard in recent years, but that's really how seriously the courts take these rights. So when does this duty arise? And in the employment context, it arises as early as the job interview. And there's a 2007 case called Brady in the Interior Health Authority, and a pharmacist a pharmacist applied for a job as a pharmacist in the hospital, and during the interview, he disclosed that he was a drug addict. And the hiring manager immediately said, well, okay, well, we can't hire you as a drug addict to work in the pharmacy. And then the hiring manager referred the matter to Human Resources, and Human Resources panicked. Because what the hiring manager did is the hiring manager made an assumption about Brady's disability and how that would manifest and interact with his workplace requirements. So Human Resources made a rapid reversal and offered to investigate accommodation options. So what Human Resources did is they wrote back to Brady and said, we've made an error. We're willing to investigate whether or not you can be accommodated. We need more information about your addiction. Where are you in your addiction? Are you receiving treatment? What are you addicted to? Those kinds of questions that would really help them drill down into whether or not the pharmacist could be accommodated. And what happened was Mr. Brady refused to provide any medical information. And this is sort of an important piece because I think so much of where these issues come up is it's really a breakdown in communication. Employers maybe don't understand exactly what they need to know about whether or not an individual can be accommodated. And individuals don't necessarily want to disclose that information. But that can actually really hurt you. Because Mr. Brady refused to provide any information, the tribunal concluded, yes, there had been a breach of the code in that they rescinded the employment offer because of an assumption that they couldn't accommodate him. But in his refusal to provide any information, the employer was left without an ability to determine whether or not he could be accommodated. So what really flows from Brady is the duty to accommodate exists at the point of hiring. We tell all of our clients that their hiring managers really need to know about the duty. Human Resources often knows about the duty and what it means, but hiring managers need to be live to it. Prospective employers are entitled to inquire if you have any restrictions that would prevent you from performing the tasks of the job. But the prospective employee has a duty to respond to those inquiries and a duty to provide the information necessary to determine whether or not you can be accommodated. So it really is a two-way street. It doesn't often come up at the point of hire. It normally comes up later in the job interview, but we wanted to flag for you that, this does exist right off the bat.
Let me ask a question.
Yes.
It's not right that I have the privilege to be in the same room and ask the question.
But I guess my question is, so are we coming to a point where employers can ask potential employees at the time of interview if they have things in the way in terms of they being able to do the job?
Employers can certainly ask those questions, and we tend to advise people not to. Because the difficulty is the second you ask that question, regardless of what the answer is, you leave yourself open to a human rights complaint. We advise our clients that it makes a lot more sense to pick a candidate who you think is suitable, and if those issues come up after the point of hire, then you begin talking about how one can be accommodated. But those are certainly questions that can be asked, and if they are asked, you do need to answer them. If you sort of said, kind of like what Mr. Brady did, I have an addiction problem, but no, I'm not going to provide you with any information. You can really see how that leaves the employer without the ability to determine whether or not there is something that can be done to accommodate you in the workplace. So we're going to move on to what must be accommodated. Hopefully that answered your question? Okay. So accommodation is only required when we're talking about one or more of the prohibited grounds. And if you're talking about something that doesn't fall within the protections, you don't necessarily need to accommodate it. So there's no requirement to accommodate, for example, a lack of skills, education, a lack of education, personal preferences, clothing, job experience, intelligence, jewelry, unless those things can be tied to a prohibited ground. So, for example, with jewelry, if your religion requires that you wear a bangle or something like that, that would be required to be accommodated. We saw this. Yeah, I was going to say we saw this years ago with the turbans and in the individuals who wanted to wear turbans who were members of the RCMP. So there can be a nexus between these things, but generally speaking, at a base level, there's no requirement to accommodate these things. So if your employer is coming to you and saying, listen, we think you have a lack of skill, it needs to be improved upon, and you know that lack of skill is related to a protected ground, you need to let your employer know that it's related to the protected ground. Otherwise, you don't get the protection of the code. So what must be accommodated? Disability is what we're talking about. Disability is not defined in the Human Rights Code, neither mental nor physical disability. Physical disability is often a lot easier to determine because they often have a physical manifestation. If I'm missing a leg, it's pretty obvious I am missing a leg. Mental disability is a little trickier. And what the jurisprudence suggests is that how they have defined disability or how they will approach disability is involuntary, has some degree of permanence, and presents some impairment on the ability to carry out normal functions of life. One of the difficulties is the idea of stress. A lot of our employers have clients say, or have their employees come and say, well, I'm stressed and you need to accommodate my stress. Workplace stress has been held, workplace stress in and of its own is not a disability under the code. But where the tribunal is sort of starting to split that hair is the physical manifestations of workplace stress can give rise to disabilities that require accommodation. So it's sort of a 6 of one, half a dozen of the other. It's not enough to just say, I'm stressed, you need to accommodate me. It is enough to say, I'm stressed, here's what the manifestation of that stress are. How do we accommodate that? Exactly. I think we have a question here. Mostly employers would say to our clients that there were more qualified applicants for this position rather than specifically address the disability. Is there an onus on an employer to prove they have more qualified applicants? If they have raised questions about the disability, yes, there would be an onus on the employer to prove that they had more qualified applicants. If the disability had not been a topic of discussion at all in the interview, then no. If the employer had no way of knowing you had a physical or a mental disability or you fell within a protection under the code, I think a full answer to any kind of complaint would be we were simply unaware and it played no part in our decision making. Hopefully, Rona, that answers your question. So some examples of what must be accommodated: drug or alcohol dependency, depression, the physical symptoms of stress, and chronic fatigue syndrome. These are all things that the tribunal has definitively said these are disabilities. Excuse me. So the employer's obligation. The employer is expected to initiate the accommodation process. Now, that doesn't happen in a vacuum. As I say, if the employer doesn't know that you have something that needs accommodation, they can't really initiate the process. They do have a duty to inquire, which we will discuss a little bit later, but the employer has an obligation to initiate the accommodation process once it becomes aware that an employee needs accommodation, and they must accommodate that employee to the point of undue hardship. And so really, I think the key takeaway here is that accommodation is a process. It's a back and forth between, two to three parties. We'll talk about unionized employees in a minute, to really arrive at what is the reasonable accommodation. Sometimes, in my experience, employees request accommodation and expect something to be dealt with immediately. And it really is a process. The employer has to consider options. They have to be fully aware of what needs to be accommodated. So it does take some time, and I know that can be very frustrating, but that's simply the reality of how the accommodation works. And like we said, they have to accommodate up to the point of undue hardship. And what is that point is a very difficult question. The key is that employees are entitled to reasonable accommodation, not perfect accommodation. So the key for employees when you're being given an accommodation or you're working through this process is that you may not be entitled to absolutely everything you want. That's the perfect accommodation. What you are entitled to is a reasonable accommodation, and it involves some compromise. The flip side of that for the employer is that some hardship is contemplated. They can't say, well, I can't do anything because it would make this difficult or it would make that difficult. So as an employee, you don't necessarily get perfection. As an employer, you have to bear some hardship. There are a number of factors that are considered in the context of an employer's operation to determine when you've reached that point of undue hardship. Factors like the size of the employer's operation. Obviously, a larger organization will have more ability to move you around and accommodate you than, a three-man operation. So Hydro-Quebec is the case that I was talking about that has kind of dialed back from that impossibility. So what the Supreme Court of Canada said in Hydro-Quebec is the test is not whether or not it is impossible to accommodate the employee's characteristics. Accommodation must ensure that the employee can work without causing undue hardship to the employer. And you have to consider all of the circumstances. So you have to consider the nature of the disability, the duration of the disability, the employer's workforce, whether or not duties can be rotated in and out, the impact on other people in the workforce. There's a whole number of things that an employer has to consider in determining whether or not they've met the point of undue hardship. So the implications that flow from Hydro-Quebec is that the emphasis is really on reasonableness. Was it a reasonable accommodation, and is this a reasonable amount of hardship to place on the employer? In meeting the undue hardship in case of excessive absenteeism, which is what Hydro-Quebec was about. In Hydro-Quebec, the individual in question, I think, had missed something like 720 days of work in the last 3 years. And what the employer had done is they had made past attempts at accommodation, and every time the employee came back to work, her symptoms were triggered and she went off work again. And there was medical information that said the prospect of improved attendance is unlikely. So in that context, where the employer had tried to accommodate the disability, where those accommodations made the disability worse again, and there was no likelihood of it improving, you can kind of see how you really do meet that point of undue hardship. So as I said, the duty to accommodate involves a number of participants. If you're in a unionized workforce, your union has a duty to participate in the duty to accommodate. Generally speaking, if you're not in a unionized environment, it's between the employee and the employer. So the employee's role is the employee must facilitate the search. They must disclose the disability, and if they fail to participate or failure to disclose medical information, you can see that overrides the duty to accommodate. We talked about that in Brady. And the employees also have an obligation to accept a reasonable accommodation. And I know that can be very difficult when an employee sort of says, no, this is how I want to be accommodated. I would really urge employees to take a step back and really listen to the accommodation options that are being proposed by the employer and really reflect on whether or not those are reasonable accommodations before refusing to accept. We're going to talk a little bit about disclosing disability. Your employer, they're not entitled to know your specific diagnosis, but what the employer does need to know is what are the symptoms or what are the physical limitations on you, and how does that affect your ability to do your job? And oftentimes where I see this breakdown is an employee comes in and says, they have a general note from their physician that says, Lou is suffering from, she has a mental disability, she must be accommodated. And that doesn't really leave my employer knowing what restrictions do I have, what are the functions and what are the limitations. And really, it's a breakdown in the communication between the employer, the employee, and the employee's physician. Because really you see doctors as advocates, which is great, wanting to protect employees, but that kind of scant information can really get in the way of furthering an accommodation. So an employee's role is that you have an obligation to show a fitness to work. If you can provide evidence that confirms you're not fit to work. If you have that evidence that confirms you're not fit to work, you may be asked to provide evidence that says, here's the list of all of your duties. What of these duties can you perform? And really what your employer is asking for there is, can you do 50% of your job? Is there a way we can have you in the workforce doing some of your work, or do you need to be off completely? And the difficulty, as I say, when employers get that vague medical notice, they don't really know what the next step is. The other thing that provides a lot of challenge to employers is when they get conflicting medical evidence or equivocal evidence. So sometimes you have a medical note that is in and of itself internally inconsistent. I saw one the other day that said, so-and-so cannot perform any of their duties, and must be off work. But then when the doctor went through the list of duties, he'd checked off that the employee in question could perform half of them. And so that internally inconsistent medical information will cause your employer to follow up and ask for more. And it's really not your employer trying to be difficult. It's really them trying to wrap their mind around how do we accommodate you. The other difficulty is where you have a conflict in evidence. And where that comes up is often you have the vague medical note from a GP saying can't come into work for 6 months, but then you have an IME or a psych assessment that conflicts with that other medical note. So how is the employer wrangling that information? Your employer does not have to satisfy unreasonable demands, and it may be to the employee in question the demand doesn't seem unreasonable. And again, this is really where discourse is important, where the employer can sit down and say, well, here's the demand that you've made. You want to work 100% day shifts, but you're on a rotation and you need to rotate through day and night, and here's how it impacts other people. It's really important to have those conversations. Your employer doesn't have to create a job where no job existed before. They don't have to assign make work duties, and they don't have to ignore qualifications or safety. And so the difficulty here is really your employer is entitled to get some economic benefit from having you in the workspace. They don't have to just create a position. And I know that can be difficult and challenging when you're working through the accommodation process. So that's sort of the accommodation 30,000-foot level. We're going to talk a little bit more about invisible disabilities, and I'm mindful of the time, so bear with me. So mental illness, really the key piece of what we're looking for is what is the nature of the obligation to accommodate mentally ill employees, and what types of accommodation may be required. And that's sort of where, that's always my starting point when I'm talking to my employer clients about this. And the real difficulty, I think, for everyone in this kind of accommodation, disabilities are so common, and there, is a fear and stigma surrounding mental illness, which I think really furthers this breakdown in communication. And you can kind of see how important communication is, from the employee or from the employer. It's really the key to the process, and the difficulty is because stigma. People try to hide their illnesses from those around them. The nature of the illness itself may also make it hard to identify. So the difficulty with sorry, we've got a comment that the sound keeps cutting off. It could be my craggy, cough-ridden voice. So when it comes to mental illness in the workplace, the employer has a duty to
switch computers.
Oh, okay. No, again.
Sorry about that, folks. We're just going to switch computers so that we have a consistent connection and don't worry about the risk of loss of volume.
Okay. Hopefully this is better. Thanks, Charles. So what I was saying was that your employer has a duty to inquire if your employer feels like, or if an employer feels like an employee's performance issues may be related to a mental disability. They can't just turn a blind eye to that. So really what we advise employers is where an employee is exhibiting, a marked shift in their daily conduct, or if there's a shift in their personality, those are the kinds of things that may trigger an employer to follow up and ask questions. And really what I see happening regularly is, there's a performance concern, the employer inquires, but because of the stigma of mental illness, the employee isn't necessarily forthright about what's going on with them. And that is where, again, that's where the breakdown in communication happens. That's where, the employer isn't really put in a position where they know if they need to accommodate or not. And that tends to give rise to a number of human rights complaints. Are we? Sorry. Okay. Thank you. So the duty to inquire places on employers a positive obligation to seek more information. So if they have a concern that something is going on, they are required to follow up and ask information. They can't turn a blind eye to subtle signs of mental illness. Now, that being said, it's a two-way street, to the extent that if an employee is struggling with mental illness, to the extent that employee can come forward to the employer and say, here's what's going on, here's how it's impacting me in the workplace, that furthers the accommodation. That makes it easier because everybody knows what's going on. And I understand that that's very difficult when you're dealing with these kinds of issues. So really when the duty to inquire is triggered is where, what the tribunal says is, the duty to inquire is triggered where the employer knew or reasonably ought to have known that there was an issue of mental illness. It's not sort of a blanket requirement. Suzanne is back. So an example of the duty to inquire is the Morris and BC Rail decision. And in Morris, the employee was diagnosed with depression and was cleared to return to work. But the way the information handling worked at BC Rail was the occupational health department kept medical information confidential, which meant Mr. Morris's managers were not aware of the diagnosis or continued symptoms. Mr. Morris was eventually laid off during a major restructuring with about 20 months of severance. He'd had a number of performance issues in the workplace, and the tribunal found that the layoff was attributable to the performance problems that were caused by the depression. And Mr. Morris had been acting out in the workplace in a way he hadn't previously. And so what the tribunal concluded is the managers reasonably ought to have known that there was something going on and they should have inquired. As a result, Mr. Morris was awarded salary for 2 years to bridge him into early retirement. So we have a question. I'm not sure what the acronym is. Okay. As someone who works at an employment service center, one of my biggest challenges isn't with the potential employee, but with the employer. How are we to police employers, ensure that they are taking proper steps to addressing disabilities in lieu of dismissing or laying off employees that don't fit in their workplace? Well, Tyler, I'm not necessarily sure that it's your job to be policing those employers. The idea of fit can be tied to mental illness. It really will come down to a matter of did the employer know that there was a mental health issue? Should they have known there was a mental health issue? And if they didn't know and there was simply an issue of fit, then that won't necessarily trigger protection under the code. Really, the body that does the policing is the Human Rights Tribunal. Hopefully that makes sense, answers your question. The other piece of it is the employer really needs to understand the mental disability, and there's a disconnect between the mental disability in general and the employee's specific experiences with the disability. And so it's insufficient, for an employer to say, okay, well, Lou has post-traumatic stress disorder, my aunt had post-traumatic stress disorder, here's how I understand that manifests, so Lou should still be able to do those specific things. What the employer is required to do is understand exactly how that disability manifests and affects the specific employee and how that employee can be accommodated in the workplace. So that is often why you see employers pushing back and asking for more medical information about the restrictions and the limitations and how a specific disability impacts a specific employee. It's a very individualized process. So the employee, did we skip one? No. So the employee obligations, So there are we've talked about this a bit. So there are reciprocal obligations of the employee. The employee must disclose information about their disability to their employer. If the employee doesn't provide that information, the employer is relieved of the duty to accommodate. We saw that in the Brady case where the employee refused to provide any further information about his addiction problems, and in an absence of that information, without that information, what the tribunals have held is, if you're asked for that information and you refuse to provide it, the employer isn't in a position to know if and how it can accommodate you, and that discharges their duty to accommodate. So, I think that the recurring theme here really is that the communication is key in these processes. Missed a slide. So accommodation, the duty to accommodate must be considered with other obligations. So your employer is balancing the duty to accommodate with a common law duty of care, and that's a duty of care to the employee requiring the accommodation, and also a duty of care to the other employees in the workplace. So oftentimes we have situations where someone is behaving really erratically in the workplace, and the employer has a duty to ensure it's safe for that employee to be in the workplace. It also has a duty to ensure it's safe for the other employees in the workplace to have that employee around, and that can be triggered, by workplace obligations about bullying and harassment, and just their general common law duty of care. If employers in a collective agreement also have a duty to provide a harassment-free, everyone has a duty to provide a harassment-free workplace. Oftentimes there are specific provisions in a collective agreement that speak to that. So when we're talking about mental illness as a defense to misconduct, rather than a global request for accommodation, this is sort of the situation that comes up where maybe there's a fit issue, or there's been some issue of misconduct, and the employer wants to discipline that misconduct, and the idea of mental illness is raised. Really what the employer is looking at is the conduct culpable conduct, non-culpable conduct, or hybrid conduct? And we'll talk a little bit about that. But really what the employer is looking at is there a connection between the illness and the misconduct? If there is a connection, you're talking about non-culpable or hybrid conduct, and the goal of accommodation would be to prevent further misconduct. If there is no connection between the mental disability and the misconduct, the employer is not required to accommodate unacceptable misconduct where there is no relation. So really what we're looking at is a spectrum here. And under non-culpable, the mental illness results in no control over the workplace misconduct. So the employee has no ability to control what's going on. That's non-culpable. At the other end of that spectrum, there's mental illness, but there's no causal link between the illness and the workplace misconduct. And where there's no causal link, that's not something that requires accommodation. Oftentimes what you end up is in the middle, where the mental illness is connected to at least some of the workplace misconduct, and what the employer is left with is to tease out how can that be accommodated? How can we deal with the conduct over which you have no control, but at the same time, how do we correct the conduct over which you do have control? So that's really the framework we're working under. And an example of that case, is a grievance matter that arose in the Surrey School District, where this is an example where mental illness was not connected to the misconduct, was found not to be connected to the misconduct. And a teacher in this case accessed and used 17 coworkers' email accounts, which may raise some privacy concerns. Suzanne is back in the room. The teacher reviewed an applicant's resume, reviewed interview questions, reviewed emails, and sent offensive emails from other people's email accounts, and then deleted incoming emails from other people's email accounts. And when the employee was confronted with this behavior, first of all, the employee denied that anything had happened, and then the IT people went through and were able to prove that it was the employee. So the employer concluded that this was unacceptable behavior, that the teacher was dishonest, and the teacher then provided medical reports stating he was bipolar. Now, the medical reports did not connect his bipolar disorder to his actions in the workplace. So the employer went and sought expert medical advice about, here's the medical information we have about this employee, here's the misconduct in question. Are the two related? And the employer received expert medical advice that said, no, the two are not related. So the employer terminated the teacher. It was grieved, and at the arbitration, three psychiatrists testified, 2 for the union and 1 for the employer. So you can really see how much medical information plays in this accommodation. And the arbitrator concluded that the union failed to show a causal connection between the bipolar disorder and the specific misconduct in question. The union psychiatrist relied on the griever's self-reporting and assumed he was in a hypomanic episode at the time of misconduct. But the evidence about the griever's behavior at the time of the conduct was not consistent with that hypomanic episode. So that's sort of how the arbitrator concluded that there really wasn't a nexus, i.e. that bipolar disorder could not explain all of the misconduct, for example, the lying. So what the arbitrator ultimately concluded was that the conduct was culpable, it was serious misconduct, coupled with dishonesty to his employer, and the dismissal was upheld. So that's sort of the worst case scenario to really illustrate what the employer is looking for in these cases is medical evidence that presents a connection between the misconduct at issue and the mental illness. And that's subject to questions. That's what I've got for you. So Tyler says, what I'm struggling with most is the assumption that employers will take obligatory steps to accommodate their employees with physical or mental disability or mental health circumstances, as opposed to just dismissing them and hiring someone else. And I understand the reticence to accept that employers will do that. This is what I deal with day in and day out, and more often than not, what I deal with is employers calling me and saying, someone has this physical limitation. What steps do I need to take now? Someone has this mental issue that's come up. How do we deal with this? How do we accommodate it? So I actually see the flip side, Tyler, of what you see. Employers have a legal obligation to take steps to accommodate their employees with physical or mental health circumstances where they are aware of those mental health circumstances. They legally cannot dismiss someone and hire someone else when they're aware of those issues and where there is a connection between those issues and the workplace. I understand the reticence to accept that, and I can see why it may seem like employers may act that way, but in my experience, the clients I work with certainly don't react that way when employees come forward with requests for accommodation. They really do take them seriously and involve us on a daily basis as to how to implement those accommodations.
So I think we have finished the general presentation piece. We have a couple of minutes just for questions, if anybody has any other thoughts or questions. I'm very interested in this last dialogue that I think helps us really understand that perhaps we have some more work to do around education within our communities and within potential employers. So I think this last conversation really speaks to maybe there's a little bit of a gap between some existing services, what we see, and then service as we're providing direct service. So thank you for that. It looks like we have a couple of people typing, so perhaps we have a few more questions, so we'll just hang on tight for those. We know we're very close to time, so if people need to scoot out of the room, we understand, but we'll just hang on for a moment. Julie says, FYI, a resource that is available to companies in Ontario is workplace mental health leadership. Thanks for that resource. Thank you. So Lois asks, can employees contact you, Lou?
The short answer is yes. The longer answer is yes, but. So we tend to act at Harrison Company primarily for employers. So where we are conflicted out, I cannot give advice to employees directly, but employees can certainly contact me if they have questions. I can run a conflict check if I'm able, I can help, and if not, I can certainly refer employees to someone who can help.
And then to that point, local advocacy offices or pro bono, like student law clinics, for example, often
So it looks like we have something coming in from Charles. It says,
Huh.
useful information. Thanks, Suzanne and Lou. I have encountered a number of employees who actually demonstrate that they go out of their way to accommodate.
That's nice to hear.
Good
And
news.
That's pretty consistent with my experience in dealing with my clients. So I'm glad that others have similar positive experience.
But I think you're right. I think sometimes just the implication of stigmatization gets in the way. And so
Yep.
when you are describing that individual who felt they couldn't disclose, you can almost see how that happens.
Yep, absolutely.
Just that trust in
Yep.
the system sometimes, right? It's sometimes hard to get there. Oh boy. All right. So we're just reading your question, Rhoda. It's a long one, so I just won't read it all out.
Yeah, that's a difficult question. Rona has asked a question really about how much information should be disclosed. I think if distilled into a nutshell. And Rona says, she's thinking that we should focus on disclosing her symptoms of anxiety and depression instead, with suggestions on how the employer could accommodate. And I think, yeah, so we sort of talked about at the very beginning, your employer isn't entitled to a diagnosis. What an employer needs when it comes to considering workplace accommodation is really a clear understanding of the symptoms, the manifestation of those symptoms, and how those symptoms impact the ability to work. So hopefully that helps, Rona. But yeah, I agree with your assessment. I think your proposed approach makes good sense.
I think it brings us to that point of, a measured disclosure or partial disclosure. So that's really helpful to give a concrete example. Thank you. I don't see anybody else typing, so I'm going to wish you a happy rest of April Fool's Day. A big thanks to our amazing people who've given us some expert knowledge today. We know that this is your place of employ, and this is what you do for work, so we're really grateful for that level of expertise. Thank you very, very much, both Suzanne and Liz. Thank you.
Thank you for the opportunity.
We'll say goodbye, folks. See you in a couple weeks for our next session.
Great. Thank you kindly.